So the question is straightforward and comes with the petitioner. Yes. You want to do it today? Do it to the courtmaster. Hearing, we don't know whether we'll allow the mention or not, because for orders and others it is okay, but for hearing you'll have to move the registry. Yes. Hearing, I don't know, will not allow hearing because you'll have to move the registry. Motion, admission and orders will grant.
Motion myself. Finally, there is an urgency in the matter. The matter can be taken up today.
Today we are not taking up.
There is an urgency.
No, urgency, what happened for the entire, all these days? Why on the last of the last?
Your Lordship, the petitioner is a widow of a CISF personnel, Your Lordship, who died in harness, and she was evicted from her in-laws from the shared household. She also has two minor daughters, Your Lordship. Now she is staying with her own parents. So if the amount is disbursed to the parents as the nominee details were not updated after the marriage, so there is an urgency, Your Lordship. If it can be taken up today at 2, as per Your Lordship.
Okay, let us see.
Affecting maximum listing for unlisted matter today, madam. Like a transfer matter, what happened?
After vacation.
May it please the Lordship. Lordship, I'm praying for listing of WBC 76 for more admission, Lordship. After vacation for admission.
May I please your Lordship? With the consent of the other side, I want to mention item number 20. My senior
22-0.
20, please. My senior is indisposed today.
Okay, you are for petitioner. You are for whom? Petitioner. Prayer made by council for the petitioner just after ensuing vacation.
So madam will come up after vacation.
After summer vacation.
Daily list item 1 for motion.
Wait. This is contempt petition alleging violation of the order dated March 19
Order dated?
in 2023.
Order
Page
dated?
15, madam.
No, what is the date?
19/10/2023.
19/10/23. Okay. This NJ Khatam. Contempt 19/10/23. WBC 4133 of 2012. Okay, take steps in 2 days. Returnable after 5 weeks. Give a date after 5 weeks. Tendency shall not be allowed.
Item 2.
Obliged.
May please the Lordship.
What is the date of the order?
It's a matter of contempt, my lord.
Date of the order?
13/3/2024.
13/3/24. Okay. Take it to council for the petition. Contempt, same order. Tendency shall not be allowed.
Much.
Item 3.
May I please, Your Lordship? Lordship, made accordance to appointment of Gram Pradhan, Your Lordship. Yes. Your Lordship, on the last occasion, Your Lordship, impede petition has been filed, Your Lordship, to impede respondent number, Director of Land Records, Your Lordship, as respondent number 8, Your Lordship. And accordingly, Your Lordship, the same petition has been allowed, Your Lordship, and cause title has been amended, Your Lordship.
No, appeals are not being taken up. The person was not there, now he has joined. They are all, they are not taking up the issues.
Appeal conclusion. Appeal conclusion. Pending আছে। Divisional commissioner question.
Heard Ms. G. Boral and the counsel for the petitioner. And also heard Mr. T.C. Julia and an additional senior government advocate for respondent numbers, for state respondent numbers 2, 3,
4, 5, 6.
4, 5, 6. And Mr.
one and
J.
newly imputed on a while.
Handing done it, standing also for the Revenue Department, representing respondent number 1 to 7.
1 and 8.
Oh, 1 and 8. Appeal of the petition filed under section 162 of the executive instructions under the Assam Land and Revenue Regulation has, which was filed on 15/12/2022 has not been taken up by the appellate authority. Hence this petition. Petition notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the valid state and departmental counsel in course of the day. The pendency of the writ petition shall not be a bar for the newly implemented respondent number 8 to take up the appeal of the petitioner. The petitioner shall produce a certified copy of this order before the respondent number 8. List after 4 weeks.
Item 4,
May I please the lordship? In this case, I silence the order dated 28/2024, annex as the page number 37. According to this order, it is hereby placed under suspension as per rule 2B2030 of the Assam Services Disciplinary Rule, with effect from the date of arrest, that is on 4/7/2023, which is already passed, 3 months have already been passed over. A criminal case has been pending against me. I was undergo in the judicial custody for a period of 56 days.
Okay.
And finally, I got released on bail by order
Your-
dated
your name?
29/8/2023.
Your name?
Adopter.
Ms. Adata and counsel for the petitioner. Also heard Mr. A. Chakravarti and government advocate appearing for respondent number.
Respondent 4, I'm appealing.
Respondent number 4 and Mr. Akbar Pujari, learned stand for the Revenue
Proceed.
Department, representing respondent numbers number 3 and PNRD. Mr. S. Datta.
Can record the name of K. Kuar.
Mr. K. Kumar, learned standing counsel for the PNRD, representing respondent number 1, 3, 4, and 6. Yes. Continued suspension of the petitioner. Right, order dated 28/5/2024 is under challenge in this petition filed on Article 226 of the Constitution of India. Petition notice returnable in 4 weeks. Requisite extra copies of the, it's a suspension matter, make it 21st July 2024. Requisite extra copies of the petition be served on the London State and Department Council in course of the day. This one so. Next, the pendency of the petition shall not be a bar for the respondent authorities to release the subsistence allowance of the petitioner.
Item 6 for motion.
This is 2018 recruitment.
Yes, no, not appear.
No, the resolution from the petitioner or enjoy justice in Matters section today. Just after answering summer vacation, Mr. T.C. Sudhir, additional senior government advocate, is present.
Obliged.
Item 7.
Wait, please. I mean,
There is no vacancy. So your petition has to be dismissed.
no, item number 7, your lordship.
Please pass over the matter.
I apologize, your lordship. My item number 9. I apologize.
Lordship, kindly pass over the matter for time being. On
Just wait, the
Item
petitioner
number
is not
7.
there. You're for the petitioner.
No, respondent, all the respondent.
Where is the petitioner? No representation from the
Or
petitioner.
you can file the note.
Or counsel representing the DAGI is present. For instance, this is the matter stands adjourned today. Let's stop answering summer vacation.
Item 8.
With this lordship, this matter may be taken up with item 25 of supply list lordship. This matter may be taken up with
Yes,
item-
yes. You're taking it up. Yes.
Lordship, both are analogous matter.
Yes, please make your submissions. You want to do it today or some other day?
Lordship, today.
Then do it.
Lordship,
Make your
actually,
submissions.
has scenarios in another code. Kindly
Andy.
must oblige.
Item 9.
Yes.
Wait, please, your lordship.
7 after summer.
Your lordship, here the matter pertains to the suspension of the petitioner pursuant to his arrest.
Ajay Kumar Chaudhary will not apply in the case of bank because it's a question of trust. Once they lose trust on you, because you are a member of the staff of the bank, and you were arrested. There's a CBI case for demanding and accepting bribe. Ajay Chaudhary will not apply in the case of bank. It's a question of trust.
Absolutely. In fact,
You just issue a notice.
I'm appearing for.
in fact, lordship, if your lordship kindly sees, I absolutely take your
I
lordship.
I have seen that. You see,
sir.
there are Supreme Court judgments which says when it comes
Fiduciary
to a
trust,
bank,
yes, yes.
then it's a question of immense trust.
Immense trust, yes, lordship. Right. But the way the matter has been carried out without informing the delinquent has some rights, your lordship, to be informed of the decision.
Not for a bank. My money is also in that bank.
Absolutely. In fact, these are
Correct.
alleged irregularities, your lordship.
Maybe I don't have an account in this bank, but it's a nationalized bank. We keep money there with a lot of faith. So if he was arrested by the okay, we are issuing a notice nonetheless. Mr. M. Sharma, and counsel for the petitioner, as well as Mr. S. Dattar and the standing counsel for the
1 to 4.
respondents. You're for all
Yes.
respondents. Next slide. Continued suspension of the petitioner. It's 27/11/2023 is assailed in this petition. In the Article 226 of the Constitution of India. Issue notice, including note, issue notice returnable on 31/7/2024. Requisite extra copies of the petition be served on the net. Counsel for the respondents in course of the day. This one 31/7/2024.
Item 10,
May I please also, by this application, we are challenging the departmental inquiry as the criminal case and the department are on same identical charges, Lordship. Even the witnesses are common. So the criminal case is fixed on 684 evidence. In the meantime, departmental evidence has started.
But
So I
Mr.
pray that
Kandikar,
that may
I-
mistake. Because same set of
I-
witnesses.
No. I always have a question. You see, you are a very seasoned lawyer in the criminal side. That's why I'm asking you. Please tell me, how will you suffer prejudice?
Because my defense will be disclosed.
No,
If I cross-examine the witnesses, because it's
No.
a trap case. My defense will be,
no.
I will present that way.
You
Because
see,
say identical witnesses.
the departmental records will not be with the police.
Lordship.
The departmental records will not be with the police. And the police records will not be there in the departmental
No.
proceedings.
No, that part regarding document, I will not be present this. Regarding the witnesses.
No, but how?
Suppose I cross, because those witnesses were cross-examined in the departmental proceeding, the same witness will come before the criminal case. So they will fill up the lacuna. That part is there. That
No.
way I may be prejudiced.
No,
Regarding documents, I will not be prejudiced. That is.
no. Even that you will not be prejudiced. You
that will
tell
be
us,
prejudiced, Lordship.
you see, in a criminal proceeding, can you, knowing your status in the criminal side,
Lordship.
now please tell me, will you permit any evidence to be brought in which is not there in the police papers, which is not there in
That part
161?
is different. That part is different.
So how will they fill up the lacuna unless
that
the
is
APP starts cross-examining his witness? He will
That
not be
way I
able
will
to.
present, because on the same facts, Lordship will kindly see the witnesses, list of witnesses.
No, but I have this question. This Paul Anthony, I don't find that there's any semblance of.
Even the charges,
this.
Lordship will kindly see. That is because
Really
demand of
same.
15,000 for
But
processing the bills. That the allegation is same in both the departmental proceeding as well as in the criminal.
No, but still,
Lordship
in the
kindly
witness,
for the, so that I could.
huh?
Lordship kindly stay the proceedings. In the meantime, criminal proceeding will be over. Till I return will let.
Well, I have to submit, sir. Appearing for the FCI respondent, my lord. Not only 1,500 that was
15,000.
demanded, but the article of charges says that he has failed to maintain absolute integrity, devotion to the duty of serving the
That is with
corporation,
regard to
honesty
that.
and faithful, and acting in a manner prejudicial to the interests of the corporation, demanding and accepting of bribe by becoming a party to the corporation, brought down the image of the corporation in the eyes of the public. This is very much important, my lord. That is, I am reading from page 51, article of charges, my lord. In a similarly situated matter, state of Rajasthan already has decided against the petitioner, my lord, and the departmental proceeding was allowed to proceed, and the department proceeding was completed, my lord. The Honorable Supreme Court has in catena of judgment, my lord. That is, may I place it, my lord. In state of Rajasthan versus BK Veena reported in 1996 SSC 417. I'm relying on para 13, 14 and 15. I will read my lord para 13, my lord. 24, 25, 26. There is yet another reason the approach and objective in the criminal proceeding and the disciplinary proceeding is altogether distinct and different. In the disciplinary proceeding, the question is whether the respondent is guilty of such conduct as would merit his removal from the service or a lesser punishment, as the case may be. Whereas in a criminal proceeding, the question is whether the offences registered against him under the Prevention of Corruption Act are established, and if established, what sentence should be imposed upon him. Standard of proof, the mode of inquiry, and the rules governing the inquiry and the trial in both cases are entirely distinct and different. Staying or disciplinary proceeding pending criminal proceedings, to repeat, should not be matter of course, but is considered a decision. Even if state at one state, the decision may require reconsideration if a criminal case gets unduly delayed. We must take it clear, we have not cast and we should not be understood to have cast any reflection on the merits of the either party in the case. What we have said is confined to the question at issue, namely desirability, possibility of staying the disciplinary proceeding against the respondent pending criminal proceeding against him. For the above reason, we must hold that the tribunal was an error in staying the disciplinary proceeding pending the criminal proceeding against the respondent. The appeal is accordingly allowed with cause, my lord. My lord, I would like to place the state of Rajasthan judgment, my lord. Here, the catena of judgment has been observed, my lord. It's a with regarding the Food Corporation of India. There was a bribe. In this case also, the bribe was taken, my lord. Vinod Kumar Kashyap versus Food Corporation of India. Facts has been stated in paragraph 2. Ultimately, the writ petition was dismissed. The Supreme Court decision, my lord, Captain M. Paul Anthony also come into play, my lord, where it has stated that disciplining.
There I am having
proceeding.
also the Paul Anthony's case.
And my lord, we are having the office memorandum.
You're
The
drawing,
Paul Anthony's case will also
My lord,
kindly see.
and thereafter, my lord, there is an office memorandum of the Food Corporation of India, my lord, wherein it has been stated that issue of charge sheet against an officer against whom an investigating agency is conducting investigation or against whom a charge sheet has been filed in court. It has to be continued, my lord.
anything else? Yes.
Regarding this Paul
And the-
Anthony's case.
My lord, my learned friend has relied on the Abdul Latif case, which was
That has
stayed,
been
my
stayed by
lord,
this
and it
court.
has been fixed for admission hearing. Therein we have filed our affidavit in opposition.
Then also it has been
Don't-
stayed. by
don't-
this.
That on that
Similar-
day, I was without instructions, my lord. That's why it was stayed, my
This
lord.
Paul Anthony's case.
Otherwise, we have filed a detail.
Para 22, you also can see 22. If the departmental proceedings in the criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is of grave nature, which involves complicated question of law and fact, it would be desirable to stay the departmental proceedings till the conclusion of the criminal case. So in view of this, the other case has been stayed, Lordship. That is Abdul Latif's case. Same against the FCI. Annexure 6, page 62. Let this matter be also tagged along with that. So same result, outcome will be the same. Yeah, that also is a trap case in the departmental inquiry. Here also trap case.
What is that matter?
That matter is the annexure 6 will also can see page 62. Same trap case and departmental proceeding. An FCI is the party. He is also an FCI employee. He is also an FCI employee. Page 62.
Okay.
Till 1907 also will continue.
Hmm?
Let this matter also come along with that till 1907 he is stating. So
Okay.
till then also will kindly protect him.
Let me examine and pass by this. In the last day, I am also trapped.
My only prayer is that till then also we can protect because it's similarly situated. Both are similarly situated.
Let me examine.
Marks.
Oblige.
Yes, item 11.
Item 11,
This matter pertains to a departmental proceeding. And the penalty, Lordship, was passed.
There's a provision for appeal. You have exhausted the appeal.
Lordship, yes.
Appeal was rejected.
Yes, Lordship.
Okay, then we issue notice.
Hearing what has happened, Lordship.
We issue notice.
Lordship may issue notice, but the penalty order has not been given effect to till date, Lordship. I'll show from the records itself, Lordship, that it was.
But
passed
that's
in-
okay. Once penalty is imposed, we can always, if it is allowed, then we can always,
That was based
turn it
upon
out.
a disagreement note, Lordship, and the departmental, the department follows a definite rule, Lordship. Under that rule, there is no provision for disagreement note, Lordship. Under the provisions of the APDCL, Lordship, which was followed while imposing penalty upon me,
no,
Lordship.
whatever penalty is imposed is, will be subject to outcome of the repetition. Right now, we are not saying it.
Yes, Father.
Because the appellate,
Because it has got a civil consequence, Lordship, and that was passed illegally, Lordship, prima facie. I will show that, Lordship. If Lordship give me
no, but
5
in
minutes,
the
I'll
appeal
show-
also, you see, the appeal was rejected. So
Maybe, Lordship.
whatever is recovered from you
It
will
was
be subject
on a
to,
preconceived notion, Lordship. And they said that, Lordship, in the disagreement note, they recorded that Lordship, I confessed, and there was no confession on my part, Lordship. That was wrongly recorded. So Lordship will look into that, Lordship. I have definite judgments of this Supreme Court, Lordship, wherein it has been said that if it is not considered whether it was confession or not, and evidences with respect to that are not laid, Lordship, it cannot be held to be a confession, Lordship. Lordship, will kindly peruse the disagreement note that is at page 85, Lordship, once.
no, because you see, there's an allegation about demand of money.
Lordship.
Then there's also allegations.
Nothing was found against me, Lordship.
And then there's an allegation that the note sheet of the departmental records were available with you in your mobile.
Lordship, those things were never produced in the inquiry, Lordship. That is my specific contention.
The
Lordship.
records would reveal methods.
Maybe, Lordship, but Lordship will kindly see the disagreement note once, Lordship, page 85.
No, whatever is being recovered will be subject to outcome of the repetition.
Lordship, prima facie, this disagreement note is illegal, and basing upon this only the penalty was imposed, Lordship. It was stated that I confessed, Lordship, but there was no confession on my part.
Where is that?
Page 85, Lordship.
85.
Lordship, may I read the whole one, Lordship? Will be-
No, not the whole one. Just tell us the
Then
relevant part.
the last two paragraphs, Lordship. While as
Because
last-
you take a plea that the confession was in a question answer form, and therefore you filled up that question answer form
Lordship,
where there was an admission.
yes, Lordship. But at least that ought to have been taken note by the inquiry officer or the.
No, but it is, you see,
departmental-
you were given questions and you wrote the answers.
That was done by force, Lordship. That was done by force, application of force,
No,
because
in
in
department
the show
proceeding, we
cause
can't
reply,
accept that.
Lordship, I have clearly stated that, Lordship, that was not taken into consideration, Lordship.
It's not believable.
Because, Lordship, at least that ought to have been taken into consideration, Lordship. That was not taken, Lordship. I'll show that, Lordship. My contention ought to have been taken into consideration by the disciplinary authority, but that was not taken into consideration. Last two paragraphs, Lordship, may I read?
Yes, I've seen that.
Then Lordship will kindly see page 73. Why I say that they did not take into consideration that. Page 73, the last paragraph, Lordship.
73.
Yes, Lordship. The last paragraph. I never confessed regarding my prime involvement, guidance, direction in carrying out demanding collection activities with P. Bhagwati in my written statement. However, on 17/9/2020, around 6 to 7:45 p.m., I was not allowed to write the answer to the questions according to my own, and I was compelled to write as per direction of the investigator. The questions and answers were dictated and compelled me to write according to their dictation. Lordship, that was in the so-called reply itself, Lordship. While after that, Lordship, the inquiry proceeding was done, and therein also nothing was recorded with regard to this, Lordship. And subsequently, a disagreement note was given, Lordship. In the disagreement note, Lordship, they say that I confess, Lordship.
This,
Page 88 also,
no,
Lordship.
this document is,
This is a so-called reply in the, it's
So-
dated,
30/12/2020.
Lordship. That was prior to the disagreement note, Lordship. They did not take into consideration this aspect. Subsequently, page 88, Lordship. After the disagreement note also, Lordship, I specifically stated at page 88, paragraph 7, Lordship. While
Where is the disagreement note?
that is at page 85, Lordship. This last two paragraphs are relevant, Lordship. Page 85. Lordship, at page 88 also, I replied, stating specifically that there was a confession only by force, Lordship, and that may not be taken into consideration, Lordship. Page 88, paragraph 7. Lordship, one more aspect is that, Lordship, under the rules under which this disciplinary proceeding came to be initiated against me, therein, Lordship, there is no provision of disagreement note, Lordship.
My lords, is a established point of law.
Maybe,
my lord.
Lordship, but they are following.
In the
set of rules,
disciplinary
Lordship.
authority, my lords, may
If-
disagree with the findings of an inquiry officer, my lords. All they are required to do is issue a fresh notice, which they have done in the present case, my lords.
But they did not take into consideration my contentions, Lordship. And Lordship, during the inquiry also, Lordship, there were many anomalies, Lordship. In that inquiry proceeding, Lordship, I sought for the video and audio recordings basing upon which the allegations were based, Lordship. Those were never provided to me at any point of time. They could not have alleged me basing on those evidences which was taken into consideration without providing me those, Lordship. I will be relying upon one judgment, Lordship. Yes.
Yes.
It was.
Petition to provide.
Oh, citation to hold. 2009 to SCC 570. 2009 to SCC 570, Lordship. Lordship, paragraph 10. May I read it, Lordship? Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer had a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said documents. The management witness merely tendered the documents and did not prove the contents thereof. Reliance inter alia was placed by the inquiry officer on the affair which could not have been treated as evidence. We have noticed herein before that only basic evidence whereupon reliance have been placed by the inquiry officer was purported confession made by the appellant before the police. According to the appellant, he was forced to sign on the said confession as he was tortured by the police in the police station. Appellant being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence. Even there was no indirect evidence. The tenor of the report demonstrates that the inquiry officer had made up his mind to find him guilty, or otherwise he would not have proceeded on the basis that the offense was committed in such a manner that no evidence was left. Lordship, herein also the same thing has happened, Lordship. And paragraph 17 also is relevant, Lordship. It was predetermined, Lordship. In inquiry, nothing was found against me, but the disagreement note, Lordship, the disciplinary authority found that I confessed, Lordship. That was denied earlier, Lordship. That was not taken into consideration. Paragraph 17, may I read, Lordship, once?
Yes.
Furthermore, the order of the disciplinary authority as also the appellate authority are not supported by any reason. As the orders passed by them have severe civil consequences, appropriate reasons should have been assigned. If the inquiry officer had relied upon the confession made by the appellant, there was no reason as to why the order of discharge charged by the criminal court on the basis of same evidence should not have been taken into consideration. The materials brought on record pointing out the guilt are required to be proved. A decision must be arrived at on some evidence which is legally admissible. The provisions of the Evidence Act may not be applicable in a departmental proceeding, but the principle of natural justice are. As the report of the inquiry officer was based on merely ipse dixit as also surmises and conjectures, the same could not have been sustained. The inferences drawn by the inquiry officer apparently are not supported by any evidence. Suspicion, as is well known, however high may be, can under no circumstances be held to be a substitute for legal proof. that was held, Lordship, by the Honorable Division Bench in the apex court. So in my case also, this applies, Lordship. There was no material brought on record to show that they had considered that contention, that the confession was taken on force, Lordship.
Still, we are not fully satisfied. You see, in the departmental proceeding,
Lordship,
this the person from whom bribe was sought for, Purushottam Bhagavati,
Lordship,
he was examined.
Lordship. He was not interestingly present in the inquiry proceeding, Lordship.
He was not examined.
No, not examined, Lordship. And the disagreement in the inquiry report, Lordship, nothing was found against me. In the disagreement note, Lordship, they said that I confessed, Lordship, and basing upon that only the penalty was imposed, Lordship. Nothing against me, Lordship. Lordship will see the findings in the inquiry report once, Lordship.
You come to page 54, paragraph 8,
Lordship.
the direct cross-examination of the Purushottam
Lordship,
Bhagavati.
this was in the preliminary inquiry, Lordship. This is not a part of the departmental proceeding. This was in the preliminary inquiry. And they brought it by way of a list of documents. This one was brought in by way of a list of documents, Lordship. These things were not listed and neither notice was served upon me that these persons would be examined in the preliminary inquiry, Lordship. And the persons who conducted the preliminary inquiry were witnesses in the inquiry that was conducted in this departmental proceeding, Lordship.
Yes,
And
Mr. Chaudhary, this person was not examined.
He stayed away, my lords. And there was, interestingly, there was a departmental proceeding drawn up against that very person also, my lords. That person had approached this honorable court, my lords, without availing the remedy of appeal before the departmental authority. But that was remanded back. What the status of that appeal and whether or not, my lords, he has
No,
been
but
found
if,
guilty.
if the person from whom bribe was sought for, if he is not examined,
Otherwise, the records would be necessary in the matter, my lords.
maybe, Lordship, but prima facie, Lordship, he was not examined and nothing was taken into consideration by the authorities. They proceeded with a preconceived notion, Lordship.
because if the witness was not examined, who is accused of being asked bribe.
There are three individuals, my lords. There were departmental proceedings drawn up against all of them.
No, but were they examined? This person is accused of asking money from this Purushottam Bhagavati.
The allegation is he did the dirty work, my lords. He was the one who was calling up people at the behest of the petitioner and one other person, my lords. The Purushottam Bhagavati was a computer operator, a contractual employee of the APDCL. And these people, the petitioner was an assistant manager, my lords. He's an assistant
So
manager.
from whom
Page
this
50.
bribe was asked for?
From candidates who had applied for appointment recruitment on compassionate grounds, my lords.
Were they examined? And any of these witnesses were examined?
That's, my lords, I'll have
Lordship, kindly turn to page 83 once, Lordship.
Page
83.
83.
This is the finding of the inquiry officer which was conducting the inquiry in this departmental proceeding, Lordship. Lordship, at the middle portion, Lordship will find after paragraph 9, during hearing of the case, the following are found. Number 1, Sri Purushottam Bhagwati is the key figure around which all the charges leveled against the charge officer revolve. But Sri Bhagwati was not present during the hearing of the case to state his position, to set the record straight in the matter. His staying away from the hearing has actually thrown the door open for questions and speculations about his conduct and involvement in the matter. Number 2, it has not been established that money was paid to any official of APDCL by any of the candidates against his or her appointment in APDCL on compassionate ground. Number 3, with the circulation on 11/5/2020 of the list of candidates for appointment on compassionate ground to the field officers seeking information on economic financial condition of candidates, the same did no longer remain a confidential document thereafter. Number 4, during hearing of the case, Sri Sambaru Borgari, son of that Torendra Borgari, age 38 years, of village Kokrajar, Borkendra Bill, a key witness stated that he had applied for appointment on compassionate ground and his late father had worked as chokidar in Pakiragram Electrical Subdivision. It is further stated by him that Sri Suman Das contacted him over mobile phone for verification of some record. As stated by him, there was some mistake in the same of his mother in his birth certificate. It is stated further by him that as per discussion over phone, he had sworn in an affidavit it as regards the correct name of the mother and the same was sent to Sri Sumandas via WhatsApp. It is also stated by him that thereafter he contacted Sri Sumandas several times as regards further developments in the matter, but there was no discussion between them two regarding money gratification. Although although some evil plan is of exploiting the gullible of candidates by holding out the bait of jobs for cash may have been in some impish mind, but because of the scheme for appointment on compassionate ground 2004, the nefarious design got thwarted. The aforesaid scheme allowing the little scope for discretion in the matter of appointment on compassionate ground, it must have been realized by one and all that appointment under the scheme would only would happen only in terms of the scheme guidelines and nothing else. In view of the statement made herein above, it is found that the charges framed against Sri Suman Das BCMR do not stand substantiated. That was the finding of the inquiry officer, Lordship.
Your punishment is to what effect?
Lordship, deduction of one increment with cumulative effect, Lordship. That increment, Lordship, I will never get if it is in my service career, Lordship, if it is imposed, Lordship. So, Lordship may kindly stay it, Lordship. And since it's a
Stoppage of 3 annual increments.
that was proposed, Lordship,
One annual
subsequently
increment.
stopped Lordship, one increment was imposed. And it has got some civil consequences, Lordship. So I am praying that please, it may be stayed, Lordship, until this case is decided, Lordship.
Yes, Mr. Chaudhary.
My lords, the records would be necessary in the matter, my lords. And because the connected persons, my lord, there were duties drawn up against all these 3 individuals. The outcomes of those proceedings.
He fled,
If I may just be allowed to submit, my lord. Now, as far as the interim goes, my lords, there's absolutely no pleading as to how there's a prima facie case, how there would be irreparable injury, or whether there would be any loss caused to the petitioner. My lord. There is no pleading to that effect, my lords. Straight away, there is a prayer for an interim relief, my lords.
No, that principle will not apply in a service matter. This is
Respectfully,
challenging
my lord,
the
there are-
decision. If you have not examined the witnesses, no witnesses has
He
said that bribe was given.
Yes, my lord. Now,
Then the petitioner has made out the case.
my lords, will then allow me to produce the records, my lords, and issue notice on the interim as well, my lords. I'll produce the record on the next day.
Lordship will do that, but from July itself, that stoppage will be made, Lordship.
Oh, immediately upon reopening, my lords, I'll get the records.
At least to that date, Lordship will protect me, Lordship.
And what do you call about these 3, the other people who have been charged?
Yes,
What has
my lord.
happened to them?
Yes, ma'am. That status I'll have to obtain because the prime accused Purushottam Bhagavati, he also challenged his because he was a contractual employee, my lord. So he had challenged his penalty. A penalty was imposed on him, and he had filed a writ petition without availing the appeal for provision, my lords. Now that writ petition was decided, giving him liberty to approach the file a departmental appeal. Subsequently, my lord, the development and as far as the disciplinary proceedings against the other accused Karan Das, my lords, I'll have to obtain instructions what has happened in those.
Okay.
Those are different.
Mr. M.P. Sharma under counsel for the petitioner and Mr. B. Chaudhary under stand counsel for the APDC. The punishment of stoppage of one annual increment with cumulative effect. Right, this,
Lordship will
right,
find
order dated,
page 91. Thank you.
right, order dated
Lordship, it's 29/9/2023,
29/9/2023,
page 91, Lordship.
and rejection of the departmental appeal by order dated 18/4/2024. The same in this petition filed under Article 26 of the Constitution of India. To notice, including notice on the prayer for interim relief, returnable 4 weeks. Requisite extra copies of the petition be served on the runner. Counsel for the respondents in course of the due. Next paragraph. As the petitioner has been able to project that, has been able to demonstrate that persons who were allegedly approached by the petitioner for bribe have not been examined in the course of the departmental proceedings. As an interim measure until the next returnable date, the penalty order dated 29/9/2023 shall not be enforced against the petitioner. So the interim order shall be revisited on the next date of listing.
Supply item 24 for motion.
May I please, Lord? Madam,
What is the order?
order. Here is the direction. to
Order
delete-
date, order date,
Order dated 14/5/2024.
14/5/24. Okay. That is, I repeat, counsel for the petitioner. Contempt. Order dated
14/5/2024.
14/5/2024. Passing WBC 1760/2024. Okay, take steps within 2 days. Notice return in 5 days. Tendency shall not be bad. After 5 weeks.
Item 25 with item 8.
May I please, Lord? My lord, the petitioner is a member of RPF, my lord, who was transferred on 21/7/2023, along with some other person. Thereafter, my lord, some of the candidate have challenged the transfer order on the ground that it was issued in violation of the directive number 58. Thereafter, my lord, the honorable court was stayed the impugned order, my lord, transfer order. In the meantime, my lord, the railway board has given one-time exemption for a period of 1 year, which I have annexed as annexure, page 27. Page 31, my lord.
Page.
Page 31, item number 8.
Yes.
Yes, madam. Reference above, one-time exemption has been granted for completion of periodical transfer of RPF personnel till 31st July 2023 in place of 30th June 2023 for the financial year of 22-23. The date of start of the tenure shall be deemed to be from 31st March 2024 only for the purpose of tenure transfer. In view of this, my lord, the writ petition has become infructuous.
Yes,
Yes, my lord. Thereafter, my lord, your lord should kindly see annexure 7,
page
page 83.
80.
83.
Yes,
Yes, ma'am. Here, my lord, it has been written like this, my lord. With reference to the above, it is to inform you that height F1 number so and so, data so and so, total 101 it officer and staffs were transferred to division over NFR through TMM. Challenging the force order, personnel have filed WBC number so and so before the Honorable Guwahati High Court, which was closed by the Honorable Court on 17/11/2023 with passing the following judgment on order. As the petitioner is still in their place of posting and they have been allowed to rejoin their new post, that is the subsequent posting of transfer up till 31st 3/2024, the present writ petition is closed as infructuous. Accordingly, in compliance of the Honorable High Court's order dated 17/11/2023, it is requested to direct all the RPF personnel to report at their new place of posting on or immediate after 31st 3/2024 to carry out their tenure transfer issued by so and so manner. After that, my lord, another order was passed, my lord, regarding the same issue, my lord. Thereafter, those candidates again challenged the this order before the High Court, my lord. And this Honorable Court was pleased to dispose it on 14/5/2024, my lord. Page 86, Annexure 9. Court have directed to raise their grievances independently before the authorities and to release their.
what is your ground to challenge it?
My lord, there is a provision for option of choices, my lord, and that was not given. I have not challenged, my lord, the other candidate. I have submitted a representation on 27/3/2024.
No, but
And
the
it-
representation you are given this, it's not a ground to consider.
My lord, there is an option, my lord. Directive number 58 clearly says the railway member can opt choices, my lord.
Where is that?
Yes, my lord.
Where is that?
Yeah, yeah.
Page 37, man, relevant page is page 45.
Page 46 to the railway. Page 46, my lord. Roman 18. All the officer staffs under zone of consideration for transfer will have to submit option of all units where they are eligible to be posted in descending order of choice.
What is your ground of your challenge?
My lord, here, my lord, I have submitted a representation that has been kept pending.
Where is
The-
that?
Annexure 10, page 100, my lord. Apart from that, the authority ought to have obtained the choices also. The other candidate cases has been considered.
Pardon me?
Other candidates cases has been considered by the authorities.
Yes.
Yes, my lord, here basically my lord, his ground of challenge is, my lord, that the directive 58, the first
No, but
directive of.
once he gives a representation, you dispose it off.
Yes, my lord, but that, my lord, that representation is on the ground of hardship, my lord. But his ground of challenge is, my lord, the violation of directive 58. Well, directive 58, lordship will find there are two directives, my lord, one of 13/3/2023 and the revised one is of 18/3/2024.
Page.
Lordship, yes, lordship has seen that.
Page.
Well, yes, well, on the earlier round of litigation, well, though he was not a party, the petitioner was not a party, there's a challenge made was that they were not given the option to exercise the place of choice, place of posting. But here, my lord, he has not exercised this option till now. But here he says, my lord, since his wife is unwell, that's why, my lord, I should be kept in my present place of posting.
Where is that clause?
Yes, no, that lordship has page 46. 45, lordship will kindly come to page 45. Clause C 16, my lord. Yes, page 45.
45.
Yes. All options available in the rank of choice. 16, man, Roman 16. So he has to give a choice of place of posting, my lord. He has not done that till now. Transfer order was of 21st of July 2023, my lord.
Just
He-
21st July.
21st of July,
July
21/7/2023. That is the transfer order. He prefers representation on 27/3/2024.
Because as covered by the exemption order.
And that order, transfer order was given effect to on 28/3/2024. He has been released, my lord. And he has been asked to report to his new place of posting. That is Alipurdwar division. Because he has completed 2 tenure, my lord. One at Guwahati and another at Lamding, my lord.
Yes, Mr. Rafiq, this ground on which you are seeking transfer is not a good ground.
Your Lordship, kindly see page 45, close
Page 45.
45,
Yes.
close 16. The grounds, my lord. When someone is suffering from a terminal illness, him or herself, being a caregiver to a disabled child, having a dependent with a terminal illness. My wife is a dependent, my lord. Children studying, this is not applicable. And my lord, the 9 number, my lord, extreme compassionate ground. These are the
No,
grounds,
see,
my lord.
this,
And apart
this,
from that, my lord,
you are not a disabled, your wife is not a disabled.
not disabled, she cannot move, my lord. And I have a small 2 kids, my lord. Moreover, my lord, my lord, I ought to have been allowed to opt choices, my lord.
Pardon me?
My lord, there is a provision of choices, my lord, which was not allowed to me. Well, similarly situated candidate's case has been considered. My lord.
He has to make representation for that, but he has to
My lord, you
exercise
must
that option.
kindly see the judgment, my lord. In the judgment,
He has to exercise the
it is
option.
allowed the petitioner to submit.
Which page?
Yes, my lord.
Which page?
Yes. Page 97. Paragraph 11.
Paragraph?
11. Page 97. Para 11. The perusal of the directive number 58 and directive number 58 revised reveal that there are provision for the railways authorities to consider the hardship and difficulties faced by the RPFs in respect of the tenure transfer. This directive clearly laid down the procedure prescribed for issuance of the transfer in respect of the railway protection force personnel. The directive reveals that competent railway authorities are vested with sufficient powers to reconsider any such application representation that may be preferred by the concerned RTF personnel expressing the hardship and the difficulties in respect of the tenure transfer issued. While clause C 17 under directive number 58 provides for a specific ground on which the priority should be given for absorption in the notified vacancies by the railway authorities. Clause C within bracket 7 of the directive number 58 provides for submission of options by the concerned RPF personnel towards cases of their posting. These options, upon being submitted, will have to be considered by the competent authority, and thereafter appropriate orders are required to be passed. Having noticed such provision available in this directive, this court is of the view that at this stage, the writ petition can be disposed of with the direction to the petitioner to file new representation individually before the Principal Chief Security Commissioner Northeast Frontier Railway Authorities, namely the respondent number 4, expressing their hardship in reference to the provision of directive number so and so, so and so. After that, my lord, this petitioner has submitted the representation and their case has been considered.
Okay, let me examine and pass on this.
And one more thing, Malad, the order, the impugn order of transfer dated 21/7/2023 was given effect to on 23rd of March 2023. Now exactly about 3 months have passed. There is no statement in the writ petition to suggest, Malad, that where the present petitioner is posted now.
whether he has
I-
complied with this order
no,
or
my lord,
not.
No, my lord, I have not
It
joined
is
any.
no whisper
I
in the
have not joined
petition, my
any,
lord.
my lord. I have not joined.
So
any.
that means, my lord, he has joined in his new place of posting,
No,
because
my
he has
lord,
not made a specific statement saying that, my lord, that the order of 28th of March has not been given effect to.
Once Mr. Rafiq is saying it, we'll accept it, that
Fine.
he is not joining. We'll take it from him.
But there is no statement in the.
I'm waiting for disposal of my representation.
Let me consider in pass orders. 8 and 24 are same.
Yes, my lord, here is the lady, my lord, during his leave period, he was allowed maternity leave. And during his leave period, he was spared leave. He has a very small salary.
What is her representation?
My lord,
Yes, Congress.
Annexure 10, my lord,
Page, give me the page number.
page 97. She submitted this representation on 13 to 24.
Okay, let me examine it first.
Yes. All right.
You are in the second matter.
Let's see. All right. All right.
Second question, this is Arjun. Arjun.
Twenty-six.
May please, your lordship. Lordship, the matter is for non-release of pension by the bank authority, lordship, particularly the bank
If
authority.
you notice, Mr. H. Talukdar and counsel for the petitioner. Your husband was the bank employee, State Bank.
Your lordship, not husband, not father. Lordship, father died in the year
No,
2011.
he's in service where?
Lordship, under the office of the commandant, lordship, lordship,
Okay,
fifth
fifth
APPN,
okay.
Sontuli Dima Hasa, lordship, commandant.
Petitioner's
Second
father was
counsel
the
for
employee of my lord.
Also,
Petition-
Mr. R.
Petitioner's father was an employee in the commandant, my lord. He died, my lord. Thereafter, his wife received family pension. Wife also died. Now the daughters are before this arrival.
Daughters and son, lordship, minor daughters and son.
Also heard Mr. R. Barpujari, learned standing counsel for the Finance Department, appearing for respondent number,
Respondent three,
Three.
my lord, treasury officer.
I appeal for respondent number 5.
and Mr. D. Bora, learned government advocate, appearing for respondent number 5.
Lordship, I'm appearing for respondent number 4 on behalf of Arshita.
Four, okay. Ms. A. Sharma, learned counsel, appearing on behalf of Mr. R. K. Talukdar, standing counsel for respondent number 4.
Extra copy given.
On the death of her mother, their mother, from other petitioners, have filed this writ petition claiming entitlement to pension on account of their father late. What is the name?
Lordship, father's name is lordship.
Khadiram, my lord.
Khadiram Rongti,
Khadiram Longki.
who was, who at the time of his death was serving in the establishment of the respondent number 5. So notice returnable in 4 weeks, requisite extra copies of the petition be served on the learned. Standing also for respondent numbers 3, 4, and 5. Next, petitioner shall take steps within 2 days for service of notice on respondent numbers 1 and 2 by registered post with AD. Next, the pendency of this writ petition shall not be a bar for the respondent number 5 to examine the claim of the
3, your lordship.
huh?
3 will be in a better position.
3.
Treasury.
No, treasury officer
Otherwise,
by
PPO
himself.
has been issued. All lordship, PPO has been issued.
Nowadays, it is
3, 1 and 2 are involved in this case.
nowadays, my lord, it is the bank authorities because the bank disburse.
The treasury has.
No, but there has to be amendment to the, this pension payment order.
Yes, perhaps that PPO has to be issued by the office of the accountant general.
Yes.
That
That is already
regularized.
issued, lordship.
PPO has to be regularized.
Regularized by the treasury officer.
So lordship will direct all the respondents.
All the respondents. And I may be allowed to take steps for drastic lordship to respondent number 1 and 2 lordship.
Okay, in addition, notice be served on respondent one to by way of justice by routing the process to the registry of the court. The pendency of the petition shall not be a bar for the respondent numbers 3, 4, and 5 to examine the claim of the petitioners. Grant of pension on account of the deceased father. Okay, let's start off votes.
Obliged, Lordship.
I'm obliged.
27,
May it please your lordship. Lordship, the case in brief is that, lordship, the petitioner was a Gao Pradhan of Katpur village, lordship. He was terminated from service on 3/2/2024, lordship. And against the termination order, he had filed an appeal, being appeal number 47 of 24 on 6/3/2024, before the respondent number 3, lordship. But on 19/6/2024, lordship.
They are taking up the matters.
Lordship, they are taking up the matters, lordship. Appeal has been numbered also, lordship. But my problem is that, lordship, an advertisement has been issued, lordship, and wherein my village has also been included, lordship. Till disposal of the appeal, lordship, the selection
So we'll
process.
permit you to move the authorities with an interim prayer. Because we have been informed that the officer was in election duty and now he has joined and taking up the matters.
Lordship,
We will permit you to move the this respond number
3,
3.
lordship.
Yes. The appeals, he will expeditiously dispose of the appeal, my lord.
No,
Because
but interim prayer also he will take it up. Interim prayer, if the
interim
advertisement
prayer,
has
my
been
lord,
issued,
if it is,
if the advertisement has been issued, he will be aggrieved by that.
Lordship. Only with regard to my village, lordship.
Okay.
There are other villages also, lordship. Only with regard to Katpur village, lordship.
It should be, my lord, that lot, lordship, particular lot, not the all of village.
No, the respondent, the appellate authority will take a call.
Yes.
Will permit the petitioner to file a prayer for interim relief.
Sure.
But Mr. P. Bordole, learned counsel for the petitioner, also had Mr. T.C. Sutial and an additional senior government advocate appearing for respondent numbers. Respondent 4 and Mr. J. Handick, learned standing counsel for the Revenue Department, representing respondent number 1, 2, and 3.
I am for 4, my lord.
Let's go. The petitioner was dismissed from the post of Gaon Pradhan of Katpar, Kathpar, Gaon. Where is the order?
Lordship, order is at page 27, annexure E, lordship. Annexure E, page 27, lordship.
This lot number is not mentioned here.
Lordship, village is mentioned, lordship, Katpar village, lordship.
He was given enough opportunity, my lord, page 27, last paragraph.
No, not that, but where is this, he's not, the lot number is not mentioned here.
Only village.
Village is mentioned,
Village.
lordship. In the advertisement also village is mentioned, lordship.
Okay,
Only village name also.
okay. So, the, Konwarpur, under Konwarpur, Konwarpur, Moza, in the, under Sivsagar Revenue Circle. Accordingly, agreed by the order of dismissal, the petitioner has filed an appeal under clause 162C of the executive instructions under the Assam Land and Revenue Regulation, 1886, before the appellate authority, i.e. the respondent number 3, on When did you file it?
6/3/2024, Lordship.
6/3/2024. Full stop. The said appeal of the petitioner has not yet been taken up. Next, the learned counsel for the petitioner has submitted that in the meanwhile, on
19/6/2024.
19/6/2024, an advertisement has been issued by the office of the commissioner, district commissioner Sivsagar, within bracket revenue division, for filling up the post of Gaon Pradhan, amongst others, of village. Where
Page
is-
14, Lordship.
Where is your serial number?
Lordship, page 40, serial number 14, Lordship.
14.
114, Lordship.
Okay. Of Katpur village under KONWARPUR Moza under Sipsaka Revenue Circle. So accordingly, it is submitted that if the advertised post of Gaon Pradhan is filled up, compromise appeal would be rendered infructuous. Next, the learned standing counsel for the revenue department has submitted that the concerned officer was on election duty and he has since joined his office and is taking up the matters, the appeal matters before him. Next para.
So far interim is concerned, my lord, I am submitting, my lord. Let them continue it, my lord. So far his village is concerned, results shall not be declared. Till
No,
disposal.
let the authorities pass an order. I'm not saying anything. We'll permit him to move that authority.
Yes.
Lordship, last
Yes.
date is 3/7, Lordship. That's why I have
Appeal is
come before this honorable court, Lordship. Last date of submission of form is 3/7, Lordship.
It's okay.
And
You'll
with
get the order today only.
Lordship, I have also submitted a representation before the district commissioner also, Lordship.
No, they will
An extra
not be able to do anything. Stop. As the court finds that the petitioner has already filed an appeal before the respondent number 3 under clause 162C of the executive instructions. Under the some land and revenue regulation, 1886. It would be appropriate to relegate the petitioner to move the appellate authority with an interlocutory application for staying of the staying of the advertisement dated 19/6/2024 insofar as village Katpur village Katpur under Kumarpur Moza under Sivsagar Revenue Circle on the ground that is on such ground as the petitioner may so deem it appropriate. Full stop. The respondent number 3, I, the appellate authority, on receipt of the prayer for interim relief by the petitioner, pass an appropriate order without any delay in the without any further delay. And by giving an opportunity of the petitioner of being heard on the prayer for interim relief. Next, the petitioner shall produce a certified copy of this order along with his interlocutory application before the director, Land Records and Service, Assam.
till disposal of this IL lordship. Otherwise,
Any?
lordship, till disposal of this.
No, 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 no.
No, no.
Somebody else is taking up the hearing, we can't pass a stay. That's why we are allowing you to go there. You'll get the order to do it.
Oblige, your lordship.
First, the direction, this petition is closed. Twenty-eight.
Eight.
May please, your lordship. The petitioners herein are all working for more than 15 to 25 years under the Hospital Management Society.
You're issuing notice.
Yes.
For Mr. K. M. Monsor and counsel for the petitioner. Also had Mrs. S. Sharma, Lanet, standing counsel for the Health Department,
All the respondents.
representing all the respondents. That's correct. Petitioners claim to have been working in various grade 4 posts for more than 15 to 25 years under the Hospital Management Society at Mangalati Civil Hospital. The petitioners claim entitlement to minimum pay oblique fixed pay scale and other benefit otherwise available to a government employee. Next. Issue notice returnable in 4 weeks. Requisite extra copies of the rate petition be served until London. Standing counsel for the Health Department in course of the day. Next paragraph. Tendency of the rate petition shall not be a bar for the respondent number.
Respondent number, lordship 6.
Respondent number 6 to examine the claim of the petitioner for minimum fees, for providing minimum pay scales and other benefits. This after 4 weeks.
Oblige, your
Take a break and come back.
Second. I mean, I said 7.
May please, your lordship. This matter pertains to appointment of constables in Central Armed Police Forces, your lordship. That one advertisement was
You
published.
see, this is an advertisement of 21/7/2018.
Yes, lordship.
We have been informed that all the posts have been filled up.
Yes.
So unless you challenge somebody's appointment, we can't entertain your rate petition. Your rate petition would be dismissed.
My lord, one similarly with similar rate petition one was issued, notice has been issued.
No, please tell me how to pass an order. Let us say that we are allowing your rate petition right now.
Not-
Now, how to allow? All the posts are filled up.
Yes, lordship.
Now, how will you allow this application? So let us say that we are allowing the writ petition right now. Please tell us the way how to do it.
At least notice may be issued, your lordship.
Please tell me. I'm giving you the entire relief right now. Please tell me how to pass an order.
My lord,
There's no vacancy. There's no vacancy. We can't ask you to be accommodated. And number two, in the next recruitment, we can't have a reservation for you.
yes, your lordship.
You can't have a reservation for
Yes,
you.
lordship. Yes.
Then
However, my lord, whatever the advertisement in the where the SSC has published at that point of time, your lordship, if your lordship go through the page number
no, please see,
49.
there's no vacancy. How can you be accommodated?
My lord,
We can't allow your writ petition. It has to be dismissed.
at least at this point, your lordship, notice may
No,
be-
no. Issuing notice is not is not very difficult. But please tell me, after issuing notice, what should we do? Today, let us say that the matter is being heard finally, and we are intending to give you relief. Please tell me how to give you a relief.
But one similar matter is pending before the.
No, no.
Supreme Court, your lordship.
You see, I don't create posts.
Yes, I
Then
understand.
the High Court can't issue a direction that the government will create supernumerary post for you. That we
Yes.
can't do.
Yes,
You unless you challenge somebody's appointment, we can't accommodate you. Your petition will be dismissed. By issuing notice, we are multiplying cases. But tell me the way how to pass an order. Today, if you allow your petition, how to pass an order? We don't have any way.
Yes. However, Your Lordship, at least this writ petition should be along with the writ petition 4-W.
No, no. It can't be. Once the entire this is filled up. Just wait, let the CGC come, someone. CGC for item 7. Just wait, we'll ask them. After some.
Obliged.
So item 12.
Lordship, in this case, we had included, because of the abolishment of the divisional commission, we had included respondent number 7 and 8, and we have taken steps upon that. But Lordship, the respondent number 5 and 6 have appeared long back, Lordship, and their names are also shown in the cause list. But in the last order, Lordship, it has been reflected to take registered step again upon the respondent number 5 and 6. But they have already appeared.
Okay. 5 and 6.
Lordship.
Mr. S.K. Das, learned counsel for the petitioner, has submitted that as per office note dated 19/12/2022, respondent numbers 5 and 6 have already entered appearance to their learned counsel. Most of their names are also found to be reflected in the cause list. Accordingly, the court is inclined to recall the directions contained in order dated 13/5/2024 for issuance of notice on respondent numbers 5 and 6. As the case is ready as regards service, place the matter after the ensuing vacation in the admission column.
Admission form, yes.
My lord, only one difficulty, my lord, I am facing practical difficulty, my lord, I am just bringing it to the lordship. This, my lord, page 4, this respondent number 2, my lord. When he filed this case, that department was there, my lord. In 2022, department has been abolished.
Oh.
Now, my lord, tribal affairs is the nodal department. If any effective order is passed, my lord, then
okay.
No, Lordship, our main concern will be, Lordship, the respondent will be Lordship, respondent 1, 3, and the newly included respondent number 7 and 8, Lordship. Because I am a ST candidate, that is why, Lordship, I have included him as
No, he is right, because this department does not exist. Number 2 is not there. So you implement the appropriate one.
Lordship.
this tribal affairs plains. That is the
Tribal affairs
department, Department of
okay.
Tribal Affairs.
Just before that, you write. Before the last paragraph, you write. Mr. R. Dhor, learned standing counsel for the respondent number 2, has submitted that the respondent number 2 has been bifurcated, trifurcated, and in the present case, the appropriate department would be
Department of Tribal Affairs, plain.
Department of Tribal Affairs in the bracket plain. The learned counsel for the petition shall take note of the same and do the needful. You want to correct it by hand?
Lordship.
Okay, do the needful. Stop. On the prayer made by learned counsel for the petitioner is permitted to amend the cause title in respect of respondent 2 by providing a freshly typed out cause title to the AOG's civil rule pending section. On receipt of the same, the amended cause title shall be incorporated in the petition, and steps would be taken for correction of the central registry. Thereafter, place the matter in the admission column.
Department of Tribal Affairs, record claim.
Okay. Item 13.
Item 13 for order implement of party.
Yes.
Applicant seeking implement of new income as my lord. Respondent number 5 and 6.
Just number 5 and 6.
Yes, my lord.
Okay. Mr. K. Kalital and counsel for the applicant submits that the applicant, who is the petitioner in the connected con case C 135 or 2024, seeks to implead the new incumbents in the respective office as respondent numbers 5 and 6 respectively. Here is allowed. This interlocutory application stands disposed of. In the connected contempt petition, you write, but Mr. K. Kalita, counsel for the petitioner, in view of order asked today in IS Civil 1955 of 2024, the petitioner is permitted to include the opposite parties in the said IA as respondent numbers 5 and 6. To stop. The petition shall provide a freshly typed out copy of the cause list to the concerned AOJ of contempt section. On receipt of the same, the amended cause title shall be incorporated in the in this contempt petition, and the central registry shall also be corrected. Next part, pending the amendment to the cause title, comma, issue notice on the newly implemented respondent numbers 5 and 6 by registered post PDD. The notice is made returnable on after 5 weeks. Or make it 6 weeks. After say on so and so. Next paragraph. Tendency of the contempt petition shall not be a bar for the respondent numbers newly implemented respondent numbers 5 and 6 to comply with the order of the court.
30 of August. Item 21 for orders. Item 21 for orders.
I'm appearing for respondent number 1, Lordship. It is your Lordship, for the petitioner. Lordship, as per office order dated 25/6/24, neither the AD card nor the answer notice
You
has
take
been
first steps
received,
for
Lordship.
respondent number 2. Take first steps.
Lordship. And Lordship, may kindly some time, allow some time for taking steps on respondent number 1, Lordship.
No, one she's there already there.
Actually,
I'm
there
appearing
is
for
on the
Lordship.
last occasion.
Earlier respondent number 1, Lordship. Now he is transferred to some other post, Lordship. The new incumbent has joined, Lordship.
Okay. Both the counsel for the petitioner and respondent number 1 are present.
Yes.
Next paragraph. The learned counsel for respondent number 1 has submitted that The respondent number one is no longer the district commissioner of Kamrup Metro, and
Yes.
the new incumbent is Sri Sumit Satawan, Sattawan. The name you'll find in the last order, right? First off, the learned counsel for the petitioner. Shall take note of the same and take appropriate steps. Next para. In view of the office note dated 25/6/2024, the petitioner shall take steps within a week for service of notice on respondent number 2 by registered post with ED. Next para. The notice is made returnable on 31/8/2024. No, not 31, make it 30/8/2024. First, the learned counsel for the petitioner shall collect the postal receipt number and submit postal track report prior to the next date of listing.
In this case also, I have already filed affidavit, Lordship.
Yes, it is there. Affidavit filed by the respondent number 1 is on record. List on 3/08/2024.
Obliged.
Item 22.
My pleasure, Lordship. Lordship, as per office note dated 25/6/24, respondent number 1 has not received a notice. Lordship,
Lordship, I am appearing for respondent number 1 and 3, Lordship.
He's left. It's not a case of non-receipt. He's left.
Okay.
You are appearing for 1?
1 and 3, Lordship.
1 and 3. Okay.
So we have complied with the orders.
Is it?
Complied. That's
Yes. You are aware of it? No. Learned counsel for the.
I appear for respondent number 2, that may be recorded.
Okay. Counsel for respondent for the petitioner and the respondent numbers 1 and 2. 1, 2, and 3 are present. Next. Mr. A. Kalita, learned counsel for respondent number 1 and 3 has submitted that by an order under number capital E 6550 of /379 dated 21/6/2024. The order of the court has been complied with and the government in the industries, Commerce and Public Enterprises Department stands by its notification dated 19/9/2015 to bring pay parity between the two posts of assistant manager within bracket technical and assistant manager within bracket non-technical in effect from 19/9/2015. So the learned counsel for the petitioner submits that she is not aware of the said development. For NJ Justice, the matter stands adjourned today. This after 4 weeks was to enable the petitioner to take to obtain instruction, the counsel for the petitioner to take instructions. The copy of order dated 21/6/2024 is retained in record. 23
Please, your lordship. In this case, I apologize that we have not taken steps, but my
Mr.
lord,
R. Fukal, learned
because
counsel
I
for
have,
the,
today itself, I have taken steps.
Mr. R. Fukal, learned counsel for the petitioner. Uh, undertakes to take steps.
Already taken, lordship.
Okay, has submitted that he has taken steps today for service of notice on the respondents. Stop. The let notice be issued on the respondents returnable on 19/8/2024. Next, pendency of the contempt petition shall be barred for the respondents to comply with the order of the court. List on 19/8/2024.
Obliged.
Time being item 7.
Yes, what is your instruction? Is the post, any post available?
In fact, 18 or 21.
2018 recruitment.
18 lordship, no vacancy is there.
No vacancy is there.
No vacancy.
Or
is
let
there.
let them file an affidavit at least, my lord.
Oh, we know about it because there is not only one
Yes,
case.
Lord.
We are deal with it daily. Each and every day we get a case of
One-
this
one
nature.
petition is already pending before this.
Pardon me?
On, one writ petition is pending before this.
No, we are not,
This-
we are not
this
bothered
may
with
not-
that.
2018 vacancy, much earlier it was filled up and adjusted with next step, recruitment process.
Mr. S.D. Royal and counsel for the petitioner.
Lord,
Petition.
Respondent authority has already done some illegal things, your lordship, that we have.
We
got
gave you an option.
Higher marks, your
You
lordship.
tell us how to pass an order. We are giving you that much of liberty to tell us how to pass an order. When there is no vacancy, we can't issue a direction.
At least they should file one affidavit that, yes.
We will put it in our order. Don't worry about that. We don't need their affidavit. But Mr. S.D. Royal and counsel for the petitioners and Mrs. B. Sharma and CGC appearing for the respondents. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioners are praying for catching of the result of the select list dated 21/1/2021. In respect of recruitment process initiated in the CAPFs, NIA, SSF and Riflemen within bracket GD in Assam Rifles, 2018. And for a direction to the respondent authorities to publish a fresh result of the revised select list in respect of the state of Assam by treating the candidature of the petitioner as in the unreserved category. Next para. The learned CGC has submitted that as per instructions received by her, all the posts advertised have been filled up. And resultantly, there are no vacancies. Considering the appointment of the petitioners. Next para. The petitioners claim to belong to OBC category. And they claim that they have secured more marks than the last candidate in the unreserved category. According to the petitioners claim, entitlement to their appointment. Next paragraph. The learned counsel for the petitioner has further submitted that under similar circumstances, in another writ petition, notice of motion has been issued by this court. Next, the court is of the considered opinion that as all the advertised posts pursuant to advertisement dated 21/7/2018 has been filled up. The present repetition is not maintainable on the ground of delay and latches. As the results were declared, were already declared on 21/1/2021. Next, the fact that a notice of motion has been issued in another repetition shall not come in the way of not entertaining the present repetition on the ground of delay and latches in approaching the court after more than years, and that too after all the posts of constables in bracket GD in CAPFs, NIA, SSF, and riflemen within bracket GD in Assam Rifles 2018 has been filled up. Accordingly, the court does not find any merit in the repression, and the repression stands dismissed on the ground of delay and latches.
Item 24, or item 14 for admission. Item 14.
Kindly peruse the order dated 10/6/2024 on.
Yes.
Lordship, Mr. B. Chaudhary's legs in another court. Kindly pass back for the matter, maybe time being also.
Okay, and you are yet to pay cost of rupees 20,000. That was imposed on the last occasion for not being there in the court. And the matter was called.
Was required to be filed. Affidavit was required to be filed, but that was not filed.
Lordship, he is coming is court number 2 Lordship, for a time being.
Okay.
Item 15 with 16.
Yes. Yes.
No, this is a matter pertaining to departmental proceeding, penalty of dismissal from service imposed upon the petitioner. Now, the first WPC
No, if you're going for a hearing, we are not taking up hearing today.
Then, my lord, some other.
If you want the rule to be issued, then yeah, I'm ready.
Yes, in
No,
fact,
Lordship,
my
let
honorable
the-
court was pleased to direct my lord, one order is there to commit for final hearing. That is the order, my lord. 11/1/2024.
No, that's okay, but we have to give options.
Yes. Let
After
be
vacation?
admitted for
After
formal
vacation,
hearing.
any date, my lord?
Date you'll have to make a mention because right now we are not fixing a date.
Lordships.
Mr. S.K. Das, counsel for the petitioner is present. So Mr. Say in one go, Mr. V. Goswami, Learned Additional Advocate General, assisted by Mr. N. Goswami, Learned Government Advocate, and you are also there. Mr. Ara, Mr. P. Kagoti, and Councillor present. First of all, this is a day just before the ensuing summer vacation. Accordingly, the court is not inclined to take up the matter for final disposal. Just after ensuing summer vacation. So liberty is granted to the petitioner, the counsel to the petitioner to make a mention.
Highly much.
Item 17.
Lordship, on
Yes, what has happened?
1/6/2024, we have forwarded a fresh proposal to the Accountant General, Lordship.
I'll take it. Yeah.
Lordship,
No, but how much time it will take?
Lordship may take something. I'll take instruction. When they receive, we receive that we will take.
it was Lordship on written on 1/6/21.
That's all right. But you have given me earlier, no, morning itself, I would have taken instruction. on that
Okay,
point.
let him get instructions.
He said, let me take.
Okay.
So I think we will do it, no?
High level.
18 with 19.
May please, your lordship.
Yes.
Lordship, learned counsel, or, is there, my lord. It's not available.
Yes, Mr. Dhar. Yes, Mr. Dhar. Yes, what do you say in the matter?
My lord will fix the matter for final disposal. I have filed my affidavit, my lord.
What is the stand taken?
Stand, my lord, today I am only in the affidavit, my lord. In the affidavit, my lord, we have taken a stand that, my lord, yes, during initially we did not in the advertisement that procedure, my lord, was not there. Later on, my lord, the government taken a decision in the highest level that without an examination, how can we recruit people? So there will be, my lord, a written examination followed by a viva. And now, initially, my lord, these petitioners, they came before this honorable court for relaxation of age. Honorable court has directed the director to consider the matter. We were magnanimous enough, my lord, 54, 55 age, we have condoned. Let them sit. Now they want to get the job without an examination, my lord. My lord, here they will be appointed as demonstrator without being examining whether they will be able to perform. How can we, my lord? So, my lord, on that my lord will fix a date and
I will, my lord, address the court, my lord. The standards of government is, my lord, without an examination, we cannot, my lord, recruit.
Initially, my lord, advertisement was issued. After 6 months, the government has issued a notification. Basis of this advertisement, a written test will be held on.
No, but what is wrong to have a
Wrong,
test?
my lord, this post, my lord, initially, my lord, earlier, so many times, my lord, there was.
My
no
lord,
written
those were
examination.
20 years,
This
25
is
years
the-
back.
This is the first time. This is the first time for written examination, my lord. From the beginning, my lord, there was no written examination. And
No,
yet
no,
the
those
training
grounds
was-
don't, will not come because if they have to choose someone, what is wrong in an examination?
Wrong.
They have condoned your age.
Somewhere, my lord, to the age of 54, 55, we have condoned that age. They will hardly they will work for, my lord, 5 years, 6 years. That also we have condoned. We gave them a chance that come and sit for the exam. Now they don't want to sit for the exam. They want get into the job directly. Somebody has passed in, my lord, 25 years back, this course. We don't know whether they will be able to perform. They will be able to go and demonstrate in the village. At the end of the day, my lord, the exchequer's money that will be paid to the as salary.
Okay, we'll fix it some other day because.
These are, my lord, very.
Okay.
Lordship, may I please, your lordship? I'm appearing in item number 19, your lordship. I have not received a copy of affidavit.
My lord,
in opposition.
it's a common affidavit, identical issue.
No, give it.
I will give a copy to him, my lord. We file it.
Oh, no.
In item number
19.
19. Okay. Um, Both sides are represented. Mr. R. Dhar, and standing counsel for the
Handloom, textile and sericulture.
Handloom, Textiles and Sericulture Department shall provide copy of affidavit in opposition filed in WPC 5655 of 2023 to the learned counsel for the petitioner. In course of the day?
Yes, ma'am. Right now, I will just make a photocopy and give.
In course of the day. Thanks, Parag. List this matter immediately after the ensuing summer vacation. Most of the learned counsel for the petitioners is permitted to make a mention if the matter is not listed.
There is interim order.
Okay, interim order passed release stands extended till the next date of listing. We give you liberty to mention. After the opening.
No, mention. Mention. We even want this matter to be disposed of, my lord, because we will have to conduct this examination. So many deserving candidates are, my lord, waiting to sit for the exam.
Okay.
Production list item BA 338/2024.
You want to withdraw it?
Yes, my lord.
You are Mr.
DK Boyddo, my lord.
Mr. DK Boyddo and counsel for the petitioner, as well as the customs is Mr. Kyal.
Mr. Ken.
And Mr. S.C. Kyal and a standing counsel for the customs department. Thanks for that. The matter is listed before this bench as the previous order was rejected by this bench. Previous bail application was rejected by this bench. Next for that. The upon instructions, the learned counsel for the petitioner seeks to withdraw this bail application. The prayer is allowed. This bail application stands dismissed from withdrawal. Please inform Mr. Kyal.
This was already mentioned, my lordship, because I intend to file a proper application, my lord.
It's okay, but inform him.
Already.
Okay.
Right.
Yes, your affidavit and 20,000 rupees.
Lordship, affidavit and IA also been filed, Lordship.
You filed?
Yes, Lordship. They are waiting outside to submit me a copy. Lordship.
Item 14.
Item 14, Mr. MP Sharma and counsel for the petitioner is present. Mr. V. Chaudhary, learned counsel for the Agriculture Department, has submitted that the affidavit in opposition is ready and a copy thereof will be served to the learned counsel for the petitioner in course of the day. So he has submitted that the Agriculture Department has also filed an interlocutory application.
Yes, Lordship,
He is in the process of filing an interlocutory application.
for modification of the order. Lord.
Accordingly, this matter stands adjourned today. This after ensuing summer vacation on date to be fixed by the office.
Item 17.
They are in actually in the March. That's why I could not contact them after some time only. Otherwise, I'll do one thing, my lord. If they have received, then I'll expect them to this one. If they have, definitely, if they have not received also, if I'll send this copy.
Okay, very good. This is item number
17, ma'am.
17.
After vacation, maybe, my lord.
Okay.
This way. In the meantime, I'll put on the
Mr.
board.
I hope and counsel for the petitioner.
Okay, number.
Mr. Anu Padhyay and as counsel for the Irrigation Department has submitted that a fresh proposal, that an amended, correct proposal. Correct proposal has been sent to the Office of the Accountant General. Mr. C. Barwar and its standing counsel for the Accountant General
That's
submitted
around
that he
4
has received a copy only today, and therefore he will forward the same to the
Office of the
Office of the Accountant General and seek appropriate instructions. Accordingly, matters stands adjourned today. List after ensuing summer vacation. Liberty is granted to the petitioner to make a mention.
Obliged.
Highly appreciated.
Proceeding.
Oh.
So, oh, government could not say that. Government could not say. Which department?
Central government.
You'll have to ask somebody to be here.
Yes, your lordship, copy has been served to them
No, you'll have to ask, you have to catch them and ask them to be here.
at 2, your lordship.
Okay.
Production list item 2, WPC 3437/24. Sulaksana versus Union of India.
May it please your lordship. My lord, I represent an unfortunate widow whose husband was working as a CIFS constable in Numaligarh. My lord, he met with an accident on 18/5/2024 and he died on 28/5/2024. Nearly 1 month has passed since his death. Now, the problem has arisen, my lord, because he joined in the service in the year 2013 on 2nd of February. Then his marriage took place on 1/12/2016. And he has 2 daughters. One daughter was born in September 2017 and the second daughter was born in 2019, 13th of October. Now, in all his service record, my lord, his father has been made a nominee, and in case of the insurance, the mother has been made a nominee. Now, the authorities are saying that unless I have any order from the court, my lord, they will disburse it to the parents. And in the meantime, after the death of my husband, my in-laws have driven me out of my house in Rajasthan. This lady has come all the way from Rajasthan. This particular district is Nimka Thana. She came and contacted me. So what I pray is, till this matter is adjudicated by this honorable court, your lordship will ask the authorities to keep it on hold. I have made my in-laws also a party. It's not that, as a son,
Yes, Mr. Chaudhary, it can be fine, hold.
only thing is that if some amount, I was,
No, that's not-
that will
ठीक
be
है,
asked.
ठीक है, I will
Mr.
keep it on.
BD Kumar, Learned Senior Counsel, assisted by Miss
SG, Miss SG.
Sanjukta Jain.
as Jain Counsel for the petitioner, as well as Mr. R.K.D. Chaudhary, Learned DSGA, appearing for the respondents. Number
1, 2, and 3, lordship.
1, 2, and 3.
4 is State Bank and 5 and 6.
Appearing for the State Bank.
5. Four. Okay.
5 and
Mr.
6 is
H.
private.
Borgohain, Learned Counsel, appearing for respondent number 4. Next para.
Next up, please. Next up, please.
The
Communicate koi diwa.
petitioner projects herself to be the wife of late Hari Singh Balai, BALAI, CISF constable, who died on, yes, died on
Died on 28/5/2024
28/5/2024.
in harness.
First of the petitioner projects that that her husband had not updated his service documents, and therefore the parents of deceased husband are the nominee. For receiving all financial benefits. This projected that the petitioner has how many children?
2 daughters, minor daughters.
2 minor daughters out of the wedlock with her deceased husband. First of it is also projected that the petitioner has been driven out from the matrimonial home after the death of her husband. Next para. You should notice including notice on the prayer for interim relief returnable in 4 weeks. Requisite extra copies of the petition be served on the learned DSGA as well as learned standing counsel for respondent number, learned counsel for respondent number 4 in course of the day. Next para. As an interim measure until the next returnable date, comma, which respondent, Mr.
All the because bank will be the disbursing authority, the commandant of CSF unit Numoligarh, and the other 2, 1 and 2.
Okay, the
1,
respondent numbers 3 and 4, i.e. the commandant CSF unit Numoligarh and State Bank of India Numoligarh Refinery Complex shall withhold the disbursement of money from PMSP account number page 17, account number so and so of in the name of the deceased husband of the petitioner, namely late Hari Singh Balai.
I'll print out the other way.
Next, list of the forms. The petitioner shall produce a certified copy of the order before the respondent number
3 and 4.
3 and 4. After that, list after 4 weeks.
My lord, your lordship will also include gratuity and all other. Gratuity will also be, this will not include gratuity. gratuity,
Okay.
pension and all other benefits. There are some leave encashment and all other benefits.
All other service benefits, financial service benefits. Okay.
Payable on the date of the government servant.
Hmm.
Payable on the date of the government servant. They have a list, palace here. My friend will communicate, man. We are-
He will furnish a certified copy to.
Gaon.
But yeah, Dirk.
Hello, I asked her, how did you get my name in Rajasthan?
You're famous.
No, yes, she said that she searched in Google. Somehow from Google, she took out my address and came in a
That's
train from
okay.
there.
You're
He is
famous.
in Bombay, he's in Delhi, everybody knows him.
No. Again, village lady, man. Means she is like from Rajasthan, very interior place. I saw. So she came and all. But
There are many unfortunate things.
yes,
we-
maybe I was telling her, so see, if their parents doesn't have any known source of income or they don't have support, I think you should give some money to the parents of the son also. That also I have told her. See, you don't think of taking, if you get 50 lakhs, at least give some money to your parents. That also I will convince her to give it on when the parents come, my lord, before this court, my lord. We'll take steps on them, my lord.
Money is the root of all evil.
But here, unfortunate, my lord, this man was waiting in the road. Then two vehicle collided and he was the victim of that collision. He was in one of the